I'm Philippe Sands. I'm Professor of Law at University College London and a barrister at Matrix Chambers and a writer. Welcome to my exp. We all know that in the 18th and 19th centuries, European countries went around the world picking up bits of territory and colonising them. It was known as colonialism in Africa, in South America, in Asia. Spain, France, Britain, Germany, Italy, Denmark, Holland, and various other countries were rather expert in this practice. That proceeded until the 20th century. And then in 1945, as the United Nations Charter was being negotiated, the countries of the world decided that it was time to bring colonialism to an end. And they did two things. They negotiated a United Nations Charter which contained two new rules. One rule articulated the proposition that every human being had minimum rights under international law. It coined the phrase human rights in modern parlance. And the second new rule was a commitment of every country in the world to decolonize, for the colonial powers to leave their colonies and to allow the inhabitants of those colonies to exercise something that is known as the right of self-determination, to be in charge of their own futures, to decide for themselves how they wish to be governed, not to be governed by outsiders or by others. That is the principle of decolonisation. Back in 1945, there were far fewer countries in the world. Today, there are about 200 countries in the world. Back in 1945, there were only about 50 countries in the world. One of those countries, of course, was the United States, which led the charge against colonialism. And it was US drafters principally, and one man in particular, Ralph Bunche, who would be granted a Nobel Prize for Peace in 1950, who drafted the provisions of the United Nations Charter, a political direction, but crafted in legal terms, which committed all countries in the world to move generally towards decolonisation. It obliged the colonial powers to commit to withdrawing from their colonies. And over a period of 25 years, that process of decolonisation, a political instinct, was accompanied by legal rules to oversee that process. And it has not been entirely completed, but it has been more or less completed as of today. This is a very, very tricky question. If we take, for example, slavery. When slavery was perpetrated in the 18th and early 19th centuries, it was not prohibited by international law. It's prohibited by international law today. So one of the challenges that we have is slavery, in the eyes of many, myself included, continues to have a legacy and consequences today. Those consequences are negative consequences. I think they include acts of racism, including institutional racism, in countries like the United Kingdom and the United States and many other countries around the world. And one of the difficult questions is, how do you repair the damage that is felt today for acts that took place many years ago and were not internationally unlawful when they occurred? And this is a sort of temporal challenge for international law. It has not been resolved, but many people, and increasing numbers of people, are thinking about that issue. Decolonisation as a process has more or less run its course, but not entirely. There are a small number of colonies that exist. Britain's last colony in Africa is called the Chagos Archipelago. The British call it the British Indian Ocean Territory. It was for a century and a half a part of Mauritius in Africa. And in 1965, the British government decided it would give independence to Mauritius, but it wished to keep hold of the islands of the Chagos Archipelago, and it detached them, it separated them. Mauritius obtained independence in 1968. It was decolonised, but it considered that decolonisation was not complete. And for 50 years, it has sought to recover the Chagos Archipelago from the United Kingdom, which has leased out one of the islands, Diego Garcia, as a United States military base. I was hired about 10 years ago by the government of Mauritius to help recover the Chagos Archipelago, and we designed a legal strategy based on those United Nations rules adopted in 1945. And eventually, we managed to get a case to the International Court of Justice. The General Assembly of the United Nations made the request for the case. And in February 2019, the International Court of Justice ruled, in effect unanimously, that Chagos belonged to Mauritius. The United Kingdom was an unlawful occupier. It had unlawfully separated Chagos from Mauritius. Why? Because, said the International Court of Justice, decolonisation is premised, as I mentioned earlier, on the right to self-determination. And the right to self-determination includes the principle of territorial integrity. When you grant a colony independence, the whole of the colony is entitled to independence.